Welcome to today's video. We are decoding EB2-NIW immigration law through the lens of attorney fees, refund guarantees, and what a so-called strong case really means. To set the stage, we will distinguish between marketing language and measurable legal strength, and we will discuss how to evaluate guarantees without falling for traps. By the end, you will be equipped to ask smarter questions, spot red flags, and choose a legal partner with confidence. Now that you know the goal, here is our roadmap. First, we will clarify the EB2-NIW category. Next, we will differentiate a strong case from a viable case. Then, we will benchmark a reasonable fee and unpack the 100% refund guarantee. Afterward, we will examine the fine print that matters and walk through a practical vetting checklist. Finally, we will visualize the process timeline, test your understanding with a quick quiz, and end with key takeaways and next steps. To begin, the EB2-NIW is a second preference immigrant category that allows applicants to forego a job offer and the labor certification process if they can show their proposed endeavor has substantial merit and national importance, that they are well positioned to advance it, and that, on balance, waiving the job offer requirement benefits the United States. This means the evidence and narrative matter more than any employer commitment. Consequently, attorney strategy and documentation quality carry significant weight. Building on the basics, let's separate a strong case from a viable one. When a firm calls your case strong, they may mean you satisfy the 3 NIW prongs at a baseline level, which is viability. However, viability is not certainty. A truly strong case pairs eligibility with robust evidence, quantifiable impact, credible expert letters, a detailed endeavor plan, and past achievements that demonstrate momentum. Furthermore, top firms maintain high approval rates by accepting only profiles they believe they can document persuasively. Therefore, initial enthusiasm should be confirmed by a clear evidence plan rather than feel-good statements. Next, let's compare firms offering a full legal fee refund upon denial versus those offering no refund. A refund policy can signal that a firm is picky and confident because it cannot afford frequent denials if it must return fees. It also aligns incentives, motivating thorough case building. However, it typically excludes government filing fees. On the other hand, a lack of refund does not automatically mean low quality. Many excellent firms avoid guarantees for policy or accounting reasons. Consequently, you should weigh the guarantee alongside track record, transparency, and the specificity of the firm's evidence plan. Moving on to fees, a legal fee around $6,000 is commonly reasonable for a high-quality EB2-NIW engagement. This number reflects the significant time attorneys spend on strategy formulation, drafting, assembling evidence, coordinating expert letters, and iterating through revisions. Because the process is labor-intensive, the lowest-cost option can be a false economy if it compromises quality. Accordingly, ask what deliverables are included, how many revision cycles you get, who drafts which documents, and whether limited RFE support is included in the fee. Before embracing a refund policy, read the contract. First, confirm whether the refund applies only to attorney fees or also to government fees, which usually are excluded. Next, examine how the firm defines a denial and whether withdrawals or missed deadlines jeopardize eligibility. Additionally, understand RFE and notice of intent protocols. Delayed client responses can void guarantees. Moreover, guarantees do not cover fraud or misrepresentation. Clarify refund processing timelines, and verify whether appeals or refiling are included. Finally, study the payment schedule to ensure the refund applies to all installments you have paid. To choose wisely, start by asking for anonymized examples of petitions and decisions to validate quality. Then, request a high-level strategy outline tailored to your profile before paying in full. Clarify who drafts expert letters and how the firm coordinates references. Furthermore, agree on response timelines, communication channels, and revision limits. Next, align on evidence gaps and create a workload plan to close them before filing. Finally, verify the attorney's licensure and disciplinary history and confirm that the practice regularly handles EB2-NIW matters rather than offering it as an occasional service. Having evaluated firms, it helps to visualize the process. First, the applicant phase includes research and consultations, engagement, evidence gathering, expert letters, drafting, and filing the I-140 petition. Next, the USCIS phase begins with receipt, possibly includes a period for a request for evidence or a notice of intent to deny, and concludes with adjudication. Finally, the post-decision phase involves planning the next immigration step if approved, or evaluating refund eligibility and the merits of appeal or refiling if denied. Timelines vary by workload, service center, and complexity. Before we test your knowledge, a quick but essential note. This video provides general education only and does not constitute legal advice. Policies, adjudication trends, and processing times change, so always verify current rules with a licensed immigration attorney. Most importantly, outcomes depend on your actual facts and the strength and credibility of your evidence. Therefore, treat this information as a framework to guide professional conversations rather than a substitute for personalized counsel. Quiz time. The question is, which statement best captures the difference between a viable EB2-NIW case and a strong one? Option A. Viable means you meet minimum criteria. Strong adds robust, well-documented evidence of impact. Option B. They are the same, and viable always means guaranteed approval. Option C. Strong refers only to having a PhD, while viable refers only to citations. Option D. Viable is about fees, while strong is about timelines. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is viable means you meet minimum criteria. Strong adds robust, well-documented evidence of impact. Meeting baseline prongs is not enough by itself. It must be paired with persuasive, credible documentation and a clear narrative to significantly increase approval likelihood. Next question. Regarding a 100% refund guarantee, which statement is most accurate? Option A. It usually covers only attorney fees, not USCIS filing fees. Option B. It guarantees approval if you sign with the firm. Option C. It always includes appeals and refiling. Option D. It applies even if the client ignores deadlines. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is that the guarantee usually covers only attorney fees and not government filing fees. Additionally, these guarantees often include conditions, and they can be voided by missed deadlines or misrepresentation. Therefore, it is essential to read the fine print. To make this practical, here is a simple Markdown checklist you can copy and paste into your notes. It consolidates the major questions and confirmations discussed earlier, so you can run a consistent evaluation process across firms. As we consolidate, remember that strong does not equal guaranteed. Always ask how the firm will prove strength with evidence. A $6,000 fee can be reasonable for specialized NIW work. A full refund policy may indicate selectivity, but typically excludes government fees. Read the fine print carefully, especially the definition of denial, timelines, RFE responsibilities, and exclusions. Ultimately, select demonstrable competence backed by a concrete evidence plan rather than relying on marketing language. To conclude, you can now separate persuasive marketing from measurable merit. You know what a reasonable fee looks like and why it reflects substantial labor. You can parse guarantees intelligently and ask the right contract questions. Finally, you have a checklist and a timeline overview to remain organized and proactive throughout the process. Before we part, if this video helped you think more clearly about EB2-NIW strategy, please like, share, and subscribe. Then, add your questions or experiences in the comments. Your perspective may help others avoid costly mistakes. Thanks for watching, and see you in the next deep dive.